Fight for Justice is brought to you by the Kia Store of Anniston and Rainbow City.
Good evening, everybody. Welcome to another edition of Fight for Justice. This week we have a guest from Birmingham, Alabama, a friend of mine that I graduated with from law school, named Oscar Price. He just started his own firm, and we're going to talk about a little bit about his new firm and what they do. So without further ado, I'd like to introduce Oscar Price.
Awfully good to be here, Freeman.
Thank you for coming. Tell us a little bit about yourself. Where you're from, where you went to school?
Freeman, I grew up in Birmingham, grew up here in the state of Alabama, went to University of Alabama undergrad and law school. Obviously, we were in school together,
Yep.
Studying together at law school. After law school, I went to work for a defense firm, and was actually a defense lawyer for most of my career until recently, and worked for a prestigious Birmingham defense firm, and now have decided to start Price and Armstrong. My law partner, Nick Armstrong, has done a lot of what we're doing now. He has a lot of experience doing that, and he also was at a defense firm. And I think what we're most excited about is a lot of times I think people find, particularly in business torts, small businesses who get in disputes with larger out-of-state corporations, it feels like an unlevel playing field. So our goal is to take that skill set that we acquired as defense lawyers and use it to fight for Alabama individuals and small businesses.
Well, I think that's obviously very important. That's some of what we do, although you guys are going to do class action and key tam type stuff. And mainly what we do at our firm is going to be car accidents, 18-wheeler accidents, some family law stuff, and then some contract and business litigation. Let's start off with, I think you guys are going to have a lot of action in your firm with class actions. So tell us a little bit about class actions and why you think they're important.
Well, Freeman, as every small business owner knows, a lot of times when you negotiate a contract with a large provider, maybe an out-of-state provider, there's not really equal bargaining power. There may not be bargaining power at all. The deal you get is the deal they offer. Whether you're own a restaurant or you're a small contractor, and you have to contract with all of these different entities for the services you need to run your business. And what we have found is a lot of times those people just aren't fair. They aren't fair with the way they deal with you, and I think our small business owners out there will know what I'm talking about. The problem is, a lot of times the way that you've been cheated as a small business owner is, relatively speaking, in a small amount, maybe on each invoice or each telephone call. Every time something happens, it's a very small amount. What the beauty of the class action is, we think, is we take your claim as a small business owner or an individual. You might serve as what's called a class representative. And what that means is that you are now serving all of the similar situated people out there. Really have an opportunity to correct a wrong that's happening not just to you, but to everyone else. Everyone else who's being charged that charge that's fraudulent, everyone else who's being cheated. So what a class action is, it means that you as the individual or as the small business owner represent all of the other people being harmed. And we take you and we present your case, and if we are successful, and if you're successful as we team together, that means that the recovery is not just for you, but for everyone else. And that's just another way to level the playing field. I used that term before. All of a sudden now, it's not just a local Anniston business against a major corporation. It's a local Anniston business who has at his or her back all of the other people who've been harmed in the same way. And that's what a class action is. It's an action on behalf of a class of people who've been injured.
Well, let's try to talk about the procedural aspect of this without boring everybody at home, because procedure, in lawsuits is pretty boring, but it's also probably the most important thing to know about, because if you don't know procedure, you can mess up and end up totally, you could end your lawsuit if you don't handle things procedurally correctly. And that's why you really need an attorney. It's one of the most important things that attorneys do is know procedure. So let's talk about the initial requirements of putting together a class
That's
action.
right. A lot of people want to know, a lot of people may be thinking, that sounds like something that's happened to me and I might be a class representative. How do I start a class action? You would call us or another lawyer who specializes in consumer protection or class action, and we would investigate your case. And what we are looking for are a few things. First, if it arises in contract, a breach of contract, we're going to look at your agreement. We may look at some invoices if that's where the injury occurred. It may be it occurred in tort, and we would first look at what your injury was, what your financial damage was. And then we would have to meet certain requirements. The requirements are numerosity, commonality, typicality, and your ability to adequately represent the class. Those are the four things the court's going to look to when the court decides whether or not to certify your claim as a class action. Numerosity just means, if this is something that just happened just to you or to a small handful of other people, it's probably not a class action. But if it's something that's happening to a large number of people, that is, that it's happening to so many people that it would be inefficient for the court system to look at each of them individually, then you would satisfy the numerosity requirement. The second, commonality. That means that the ways in which the members of the class have been injured have to be common to each other. Mm-hmm. If you're injured in one way and my injury is a little bit different, then we wouldn't have what's called commonality. So at Price and Armstrong, we would look at your claim to determine whether or not there's commonality. That is, has the way you've been injured, is it common to the other people who we would want to make a part of the class? And then typicality. What that just means is if you're going to be the class rep, there doesn't need to be anything in your case that makes it unique or would make you a bad class representative. If your contract, if let's say the class arose out of a breach of contract, if your contract is a little different, if your contract was negotiated separately and you have different terms than most other members of the class, then we wouldn't have typicality. And the last thing is the adequacy of representation. That means are you, and importantly your lawyers, do you have the right experience, the right financial backing, all of the things that would be necessary to be a good representative of the class. That's where it's really important to find the right lawyer to represent you. Because the court's going to be looking at that lawyer when determining whether or not the adequacy factor is met.
Yeah, and when we come back from break, we'll talk a little bit about the general types of class action suits that are available to people, and then in the third segment, we'll talk about specifically what you guys are investigating. So thank you for watching, and we will be back in a couple of minutes. Welcome back, everybody. We're going to start off the second segment talking about the general types of class action suits that are available, the types, whether it be injunctive relief or money damages, and then a little bit about the procedure of how to get a class certified, how counsel is chosen, and how notice is given. Oscar, why don't you tell us a little bit about the two types that we're at least going to discuss here tonight, injunctive relief and damages. Why don't you start off with injunctive relief and tell us a little bit about that?
Well, if you decide you want to be a class representative and you come talk to someone like us and we file a class action for you, there's probably two things that you want to happen. The first is you want whatever that company is who's cheating consumers, you want them to stop doing that. As they go forward, you want some kind of order from a court that says they can't do what they're doing anymore that's unfair to the consumer or to the small business owner. In legal terms, we would call that injunctive relief. An order from a court saying, you got to stop it, guys. But you also very likely may want money damages for you and for the other members of the class. If there's some fee that's been charged to you that's not fair, that's in breach of your agreement with them, that's fraudulent, you're going to want some of that money back that you've paid to that company that you shouldn't have paid. In layman's terms, that's the distinction between injunctive relief and money damages. I think it's also important to remember, though, that if you're the class representative, you're serving the class. You, in a sense, work for the class. You help direct the lawsuit. So on top of your actual damages as the class rep, if we're successful, you're likely to get what's called a class representative fee, which means above and beyond the recovery that everyone's entitled to as a member of the class, you're going to get a fee for the time and effort you put in to do this service to the community and to the other members of the class.
And let's talk briefly, again, not to bore everyone at home, but the procedural aspect of this, how to get a class certified and the notice and how class counsel would be chosen. Let's talk briefly about that for the viewers.
Well, because when you file a class action, the court wants to make sure that not just you, but all members of the class are protected. There are some pretty stringent procedural requirements that we as the lawyers have to go through to make sure that your claim can be presented as a class. We talked before about the things we would have to do to get a class certified, the things the court's going to look to. You know, you're not going to want to bring a claim unless there's a chance it can be certified. So that's going to be one of the first things you look at. Moving on from there, as the case progresses, if there is a resolution, or either by judgment or by settlement, the court's going to want to make sure that all the members of the class are given proper notice, proper opportunity to either participate in or opt out of the class, and that their rights are protected as well, the class members. That's what I think you were talking about when you asked about the notice requirement.
Correct. And the courts can they can choose not to honor a settlement because if they don't feel the class was adequately represented, or if someone hasn't been given the opportunity to opt out.
That's exactly right, Freeman. That's another reason that it's very important that you are careful in selecting the lawyer you use to bring a consumer protection action, any kind of a class action. Because, you know, unlike some cases, you pick your lawyer, that lawyer's fighting for you, you go to court, you win or you settle, you're in good shape. Because as a class representative, you are representing the class, the court's going to make sure that the lawyer has done all the things that he or she was supposed to do to protect all the members of the class. And if that didn't happen, you could end up in a situation where you've negotiated a settlement that the court undoes, the court doesn't approve.
All right, well, let's talk a little bit about what you guys at Price Armstrong are investigating right now. And I think you said, you told me before we started today that you guys were investigating some TCPA classes. Tell us what that acronym means and what how consumers are being cheated in this way.
You know, some of your viewers may remember in the early 90s, Congress passed and the President signed a law called the Telephone Consumer Protection Act, or the TCPA. As you might remember, it was supposed to protect us from those annoying and intrusive phone calls we receive when we're sitting around the dinner table with our family, or maybe at your business when you're trying to get things done, or worse, maybe on your cell phone where you're paying for your minutes and you're paying for your texts. So the Telephone Consumer Protection Act is a law that states what commercial entities can and cannot do when they try to solicit business from you. I think the thing a lot of people aren't aware of is that late last year it was revised, and there are some new regulations that have gone into effect that really protect the individuals and consumers. And basically, under the old and the new regulations, what the rules state is that commercial entities cannot use an auto dialer to call your house or your cell phone. An auto dialer just means some sort of computer software that's picking numbers at random. If you get a phone call from a commercial entity, there's a pretty decent chance they used an auto dialer to pick your number. It also means you can't get called with a robocall. I think everyone knows what that means. That means it can't be a computer on the other side. And importantly, these protections extend to text messages and to faxes. You know, just by way of example, Best Buy. Everyone knows, is familiar with Best Buy. Best Buy settled a $4.5 million TCPA case within the last couple of weeks, where they were using an auto dialer to reach out to consumers and bothering consumers. And this can happen to consumers or small business owners. Under the TCPA, the damages can be as high as $1,500 per inappropriate phone call or text. So it's really a good law that protects us as citizens from something that is annoying and had gotten out of control.
Could you tell us a little bit, does the do not call list, I think that's something that people are very familiar with, and they go to a website and they put in their number that says they're not allowed to be called at all. How does that interplay with the revision of the law?
Well, this is a part of this, right? You're supposed to be able to register your number and register your number to keep these calls from happening, and that is protection you have. But the TCPA, you have rights and remedies under the TCPA whether or not you've ever taken the time to do that. If you get a call from a robocall from a commercial entity, and I will caution that's important. I know this time of year we get a lot of calls from elected officials.
That was going to be my next question.
Those are not TCPA claims. Charitable organizations, they're exempt as well. So, you know, you're
so
just
the
going to have to.
politician can robocall everyone in his district or his state as many times as he wants.
You know, maybe write your congressman if you would like for that law to extend to politicians, but I don't like our chances of getting that changed.
It is somewhat funny.
It is, isn't it?
It's somewhat funny that they would be exempt of everyone. The people that probably do it the most, they're somehow exempted from the law.
Somehow I don't think that surprises anybody, Freeman.
I'm certainly not surprised by it. In the next segment, I think we're going to run out of time here. We're going to talk about another class that you guys are investigating with surcharge and fee class actions.
That's correct.
And there may be restaurants here, local bars as well, who may have claims in this type of class action, whether it be, I think you mentioned, basically delivery services for food, isn't that right?
That's right. Well, Freeman, we'll talk about in the next segment some of the biggest victims of class actions, of things that we would call class actions, are people who face fees and surcharges for materials or things they need to do their business. And a lot of times what we've found is they aren't being treated fairly. And so we'll talk about that in the next segment.
Yeah. After the commercial break, we'll come back and talk about that, and then talk about some whistleblower actions that are important, especially in this area. See you in a few minutes. Welcome back to the third and final segment of tonight's show, Fight for Justice. With me is Oscar Price from Price Armstrong in Birmingham, Alabama. It's a new firm they just started. They're going to be handling class action suits and key TAMs and numerous other things, but tonight we're specifically talking about different class action suits that they're investigating, and then some whistleblower stuff we'll talk about later in this segment. If you could, Oscar, tell us a little bit about the fuel surcharge claims you're investigating.
Thank you, Freeman. At Price Armstrong, we've got a couple cases going right now that arise out of fraudulent fuel surcharge fees or environmental fees. And what I'm basically talking about is if you own a restaurant, or if you are maybe a contractor, some sort of construction worker, really anybody that has to have materials or equipment delivered to your place of business or to a job site, you might have noticed on your invoices different kinds of fees. They might be called administrative fees or environmental fees or a fuel surcharge. In fact, I would encourage all your viewers, particularly your small business owners, pull out your last invoice and see if there isn't a fuel surcharge fee or an administrative fee or an environmental fee on that invoice. Now, just because there is a fuel surcharge fee doesn't mean that you've been wronged. It doesn't mean that there's a class action. But a fuel surcharge has a very specific definition. And what we found is that far too often, maybe the people who deliver your food, if you're a restaurant, or the people who deliver your materials, if you're some sort of a construction entity, any kind of service that's delivering to you some large out-of-state service, that there may be a fuel surcharge on your invoice, but when we investigate, what we find out is that's not actually being used to offset fuel cost. Really, it's just a scheme to increase their profit margin. And I know for our small business owners who are probably running on some pretty tight profit margins, it's a little insulting, and it's frankly just unfair when you have people who have unequal bargaining power to begin with, who are now taking something like a fuel surcharge or an environmental fee and abusing it and manipulating it to take advantage of small business owners.
You mentioned some specific types of businesses that may be putting on administrative fees or environmental fees. You know, say if you have a restaurant, or you have, I guess, anything where a large company is delivering goods to you.
Yeah, the two main things would be if you've got a contract You got a contract for delivery. It doesn't necessarily mean you wouldn't have a class action without a contract, but that would tend to indicate you might have a class action. If you have a contract, if the contract defines what a charge is supposed to be for to deliver something, and if they're charging it and using that money for something else. So, for example, there may be a restaurant out there that's paying a fuel surcharge for delivery of the food that they cook to serve to their customers pursuant to a contract, and it may be that that fuel surcharge is not actually being used to offset fuel costs. We wouldn't know until we looked into it, but if you think you might have a case based on an administrative fee or an environmental fee or a fuel surcharge or any other add-on fee on your invoice that based on your contract you don't think is being charged fairly or used for the correct purpose, give us a call and we'll look into it for you.
Yeah, I mean, I think that should make sense to everybody. If there's a fuel surcharge put in place on a small business and then the price of fuel drops to $2.50, then the fuel charge doesn't go anywhere. That's not fair.
Yeah,
to
that's an
small
indication
business.
that perhaps something unfair has happened to you. Absolutely, Freeman.
Let's also talk about the wage and hour investigation that you're doing as maybe part of trying to put together.
That's
a
right.
class.
The FLSA is the legal acronym for wage and hour cases. I think all your viewers know that we have minimum wage laws in this country, but we also have laws that state that if you work more than 40 hours in a week, you're entitled to time and a half as overtime pay. And there are a lot of specific industries that we're finding that they aren't appropriately paying their employees. The home health industry is a big one. Certain classes of people are exempt from the laws and certain classes are not exempt. We probably don't have time right now to go into the criteria of exempt or non-exempt, but it may be that you're a nurse, an RN, or an LPN, and you've been told by your employer that you shouldn't get paid by the hour or that you're exempt from the laws, minimum wage and overtime laws. You shouldn't get time and a half. And we find that's happening, and based on our investigations, in fact, those employees should be entitled to time and a half. So you might call us, we would look at it, and we might file a wage and hour class action on behalf of you and all of the other nurses who aren't getting paid time and a half, or who are being asked to do work on their lunch break, or being asked to do work before or after they clock in. These are common FLSA violations that we found. Another industry where it's far too common is wait staff, particularly wait staff who work for large sort of nationwide franchises. Applebee's, well, I mean, I won't single out any particular restaurant. I use that as an example of the types of restaurants who sometimes may ask employees to do work before they clock in, or after they clock in, or on their lunch break, do work off the clock. And that would be what we would call a wage and hour case.
Okay, and that's, you know, this is Calhoun County. There's a lot of federal government employees here. Let's tell the audience a little bit about the QTAN stuff you're doing.
Yeah, at Price Armstrong, we're also investigating some QTAM actions. That's a Latin phrase. You know, lawyers like to use Latin to sound smarter than we really are. It's called the False Claims Act. And it's a law that simply states that a company that gets money from the government may not submit a false claim for payment from the government. Now, who all gets money from the government? Well, the healthcare industry. If they submit a claim to Medicare or Medicaid, they're submitting a claim for payment. I know in Anniston we got a lot of government contractors around here. People who do work for the government get paid directly by the government. They submit a claim for payment from the government. And what the law says is that if you work for one of these companies, or even if it's your competitor, if you have non-public information that somebody is submitting a false claim for payment to the government, you can be a whistleblower and you are protected by the False Claims Act. At Price Armstrong, we represent whistleblowers. And all that means is that we would work with you and probably the federal government to recover money for the taxpayers, recover the money that was fraudulently taken from the taxpayers by the healthcare company that is submitting fraudulent Medicare claims, or by the contractor that's submitting claims for payment for work that they never actually did. Anybody who works in one of these types of industries who's aware that their employer may be cheating the government in some way, we would represent you as a whistleblower. And what the False Claims Act says is that as the whistleblower, you are entitled to a significant portion of what the government recovers. You, in essence, are recovering money on the government's behalf, and you get a financial reward for blowing the whistle on that improper conduct.
And I think that's very, very important. I think that's really all the time we have tonight. I do want to mention that sometime, I don't know a specific date, but sometime in the next few weeks, we're going to be having a special here that's going to talk about hip replacements and the actions going on with those. And it's another consumer protection type stuff, product liability. It's going to be very important, and we hope you'll tune in for it. I think that's all for tonight. Oscar, thank you for being here with us tonight. I hope that the viewers enjoyed it and learned a lot. I hope we didn't bore you with the procedural aspects of the law and class actions, but we thank you for watching, and hopefully we'll see you next week.